good morning, depending on one's location. We are glad that you could make time to join us today. Indeed, I would agree with Hiro all the way. Thank you for making time this early to join us for this session this afternoon here. We as NCIA are glad that you have honored the invitation to join a conversation which will be canvassed by a stellar panel here. And so we look forward to your engaging participation. I have been with each and every one of the senior ladies and gentlemen here, and I can guarantee you we are in for a good treat this afternoon. So back to Jackie. Thank you too for hosting us today. Thank you. Welcome.
Thank you, Lawrence. And as Lawrence has said, a special welcome to each and every one of you. Mediation, of course, a very timely conversation around what's happening, global developments around mediation and local developments that our participants will share. Our panelists will share with you participants. A couple of housekeeping announcements. If you have any questions, feel free to use the Q&A panel. We'll be happy to respond to your questions if we have time directly during the webinar or through the chat feature as well. And for that reason, your microphones are muted and your videos are muted as well. That's for our participants. Our panelists, welcome each and every one of you. I'll go ahead and introduce you. It's a very humble task for me this morning, this afternoon, depending on where you are in the globe. And I will begin by introducing Indrani Govenda. Indrani is joining us from Durban, South Africa. She is an entrepreneur of about 2 decades experience in the field of mediation, and she has worked extensively in human resources, labor relations, workplace mediation, land and commercial disputes, a broad array of disputes that she has handled. She has been a mediator on the land rights management project since 2007, which is when it was inaugurated. And she's currently a senior mediator on the panel working predominantly within communal property associations. She is associated with the Royal Institution of Chartered Surveyors, popularly known as RICS, as well as the Center for Effective Dispute Resolution, popularly known as CEDA. She's an accredited mediator and arbitrator and trains mediators in commercial mediation at RICS. As late as last Friday, I believe, Indrani, you were conducting a training, and she has successfully trained delegates in over 10 countries across the globe in dispute resolution services. She has also arbitrated in labor disputes at various institutions and has presided as a commissioner on unfair dismissal disputes. She also lectures postgraduates in the field of ADR at the WITS, that's the University of Witwatersrand in Johannesburg, in the field of, in the School of Construction, Economics and Management. So welcome, Indrani.
Thank you, Jackie.
All right. I'm starting with ladies first, so allow me then to introduce Funmi. Her full name is Olufunmilayo Ajike Roberts. So we'll just call her Funmi for today, so it's easier on the tongue. She's a solicitor and an advocate of the Supreme Court of Nigeria. She is the founder and principal partner of Funmi Roberts and Company, one of the largest female-owned law firms in Nigeria. She's a chartered arbitrator of the Chartered Institute of Arbitrators UK. I believe that's a very recent commendation. A member of the Global Panel of Mediators of the Center for Effective Dispute Resolution in the UK. A tutor and assessor with both the Chartered Institute of Arbitrators and the Center for Effective Dispute Resolution. Funmi belongs to several professional bodies and was recently appointed to the panel of neutrals of the Nigerian Electricity Regulatory Commission and is a co-visioner of the COVID-19 initiative. Funmi has received global recognition for her dispute resolution expertise, especially in 2017, when she was appointed a member of the ICC Arbitration and ADR Commission, that's the International Chamber of Commerce. Thank you and welcome, Funmi. Thank you for accepting our invitation. I will proceed to then introduce you to Professor Hiro Aragasu. Hiro is also a fellow of the Chartered Institute of Arbitrators, a distinguished neutral with more than 20 years of experience, including almost a decade of full-time practice at global law firms and service as a neutral since 2001. He is an internationally recognized expert in arbitration and mediation, and he has had the privilege of training judges and lawyers, and is frequently called upon to consult on ADR reform projects around the world. As an arbitrator, Hiro strives to design and manage the optimal procedure for a particular dispute. He's familiar with civil and common law adjudicative approaches. As a mediator, he is known for investing extra work prior to the mediation to narrow the issues and ensure that parties and counsel come fully prepared. Hiro is a dual qualified lawyer in both the US and the UK, a professor of law at Loyola Law School in Los Angeles, and a professorial research associate at the School of Oriental and African Studies at SOAS School of Law, London. Welcome, Hiro, and good morning. And finally, by no means least, Justice Fred Ochieng, who is joining us from Kisumu City this afternoon. Justice Ochieng is known to many of our participants. He is a judge of the High Court of Kenya and a certified mediator. Prior to joining the judiciary, he practiced as an advocate for 20 years with a focus in civil and commercial litigation. He has contributed immensely to successful initiatives in the judiciary towards improved access to justice, and has served as presiding judge of the Commercial and Tax Division of the High Court at Nairobi, Kakamega, Eldoret, and Kitale. He is currently serving as the presiding judge, Kisumu High Court. Justice Ochieng has also served in various elected leadership positions as president of the East African Magistrates and Judges Association and as president of the Kenya Judges and Magistrates Association. Welcome, Justice Ochieng. So welcome to each of our panelists. Karibuni nyote. We'll just dive straight into it. I'll start with you, Indrani. So currently in this COVID-19 dispensation, we've heard a lot about virtual hearings, virtual processes, virtual mediation, virtual ADR, but perhaps those of us who have been in ADR practice for a while are aware that online dispute resolution is an established practice since the UNCITRAL technical notes on ODR in 2016. Any comments on the new preference, perhaps, or the new necessity for online dispute resolution?
Thank you for that, Jackie. Yes, in actual fact, as we know, the UNCITRAL technical rules was discussed with the working group around 2016. What COVID has done is it's amplified the mechanism of ODR, whether it's mediation, arbitration, adjudication, expert determination, and the like. So it's certainly something that's been around for a good few years, the online dispute resolution medium. And from a mediation spectrum, within the spectrum of ODR, mediation is certainly gaining traction. And particularly, I'll discuss the benefits of that a little bit later. But essentially, I'm finding that there's a lot of interest in becoming accredited as mediators, both with international accreditation in particular. I'm fortunate enough to preside on both the CEDA and the RICS spectrums. So there is an interest certainly for training to become accredited as commercial mediators in the facilitative and evaluative models of mediation. And online mediations are certainly, I'll talk a little bit more around the challenges that we have in Africa, but essentially online mediations are certainly becoming more and more prevalent around the globe. And we see it on LinkedIn, we see it in our respective international networks, that it's certainly something that's growing in leaps and bounds in our new normal. So it's very encouraging, because for me, it's certainly a preferred mechanism to expeditiously resolve disputes in the commercial civil landscapes of disputes. So that, in essence, is the growth of mediation in particular during this forced, let's call it, new normal to get onto the online space.
Thank you, Indrani. Are there any, you alluded to this, are there any benefits to mediation as against other forms of dispute resolution?
Absolutely. For me, it's certainly the expeditious nature. the fact that, you know, it's something that you don't have to be dependent on the availability of arbitrators, and you're not, you know, thrown into the nets of the long-winded court roll, waiting for your case to appear or to be put on the roll even. It preserves relationships, as we know, and because it's self-determined, because, you know, your mediator is facilitating the negotiation between the parties in a dispute, whether it's two individuals or groups of people, you will be having a much more self-determined outcome. And following on to that, clearly, it then becomes more sustainable, because unlike litigation or arbitration, it hasn't been enforced upon the parties by a person who's basically just complying to procedural rules or looking at, you know, the balance of probability determinations from the claimant and the respondent. So mediation certainly brings out that win-win outcome, palatable, you know, let me say, the high rate of compliance, because like I mentioned, of the self-determination. And then we have the customized agreements where it's unique to each party, because mediation allows the parties to come up with creative solutions to their disputes. So it's not just copy and paste type agreements, and there's a great degree of control as well because of the personal engagements that the parties have. And obviously, you know, the privacy, the confidentiality, that makes it much more encouraging for, especially for commercial disputes, because you don't want to air your trade secrets amongst other dynamics into a public domain. So the private nature, the confidentiality, the voluntary nature of it, the non-binding, the without prejudice, should the mediation fail. So these are all imperatives for me that make mediation a go-to, a preferred mechanism for expeditious resolution of disputes. But more than anything else, it's the preservation of relationships, because ultimately we're human beings, and you know, we need to rely on each other, particularly in the commercial space, to continue those interests, the projects that you may have that may have come to an impasse. And when you have a winner and a loser, ultimately those people are not wanting to engage to the extent of completing the project, and you know, you're left with a very bitter and often broken relationship, not to mention broken bank balances and psychologies.
So just based on your experience, especially the South African perspective, perhaps tell us a little more about your personal experience in mediation, the South African experience in terms of the court rules that facilitate mediation. And of course, you know, in your introduction, we heard that you've dealt with a lot of land disputes. So tell us a little more about that. Okay,
Jackie, let me start first with the for me, which is considered to be a huge breakthrough. We are in the system for court annexed mediation. That's been piloted at least 5 years back. It hasn't quite taken the kind of traction that we anticipated based on a number of obvious factors. But having said that, just prior to COVID, to be specific, on the 9th of March 2020, there was an amendment or a promulgation to a rule of the courts, which we call the 41A rule amendment. That rule has now given greater credence to mediation as a mechanism to you know, obviate frivolous disputes going into the litigation space. So both the lawyers for the claimant and the respondent must make concerted efforts to mediate their disputes privately before they put it into the court roll. And there will be an adverse cost order if at the end of the trial, if the lawyer or if the judge determines that this was just a frivolous application into the system. So it's got a lot of bite. Despite COVID, you know, placing a lot of challenges to lawyers in practice, there's already been 2 cases that were awarded adverse costs. So it's a very, very encouraging, dynamic, optimistic, joyous space for us alternate dispute resolution practitioners, particularly someone as passionate as myself, to see that for the first time in many decades in South Africa, mediation has now got a real bite to it, and parties hopefully will get to see the real benefits of mediating, and lawyers are transforming their mentalities, because let's be clear, I mean, you know, people joke about it, but for a very long time, ADR was considered to be an alarming drop in revenue for practitioners that were in the litigious, space. But thankfully, a lot of them are now, this is where we're keeping busy, by the by, where lawyers and advocates want to be trained in mediation and become accredited in it, so that they can now apply, firstly, understand the advocacy, and secondly, be of relevance in their respective spaces, given the changes that are emerging from the online space, as well as the amendment to the law. Coming to my land work, it's clearly very heartbreaking, because the reality is that in Africa, we don't have the luxury of air-conditioned, remote sort of mediations, because a lot of my parties who are living in off-the-grid places, in rural spots in this country, don't have the luxury of cell phones, let alone networks to bring Wi-Fi to them and to have the engagements of this. So, and what we're actually seeing in SA at the moment is where there's an interdict for maybe evictions. So within the space of land rights, the only mechanism at play right now is for evictions, which obviously lawyers, it's going into the court system. Hopefully we'll get back on the ground once COVID has, that it's stabilized. Although we're in lockdown 1 in SA, I particularly will not be leaving home, because the challenges out there are still very real. And parties, if I have to engage with my parties, I have to ensure that there's full compliance with respect to PPEs, not just from sanitizers and gloves and temperature checks. There's a whole host of things that we must take account to. And so we've decided that online mediation with the land spectrum for this point in time is something that we're trying to innovate around, but we quite haven't come up with a mechanism to address or redress those issues. But fortunately, for extreme matters, there is representation in the courts to obviate undue, let me say, discrimination against the rural people that are compromised by these various actions on land and farms and things like that. But having said that, also, even with the online mechanism, thank God we still have a working democracy. Everything else may not be working right now. So I can take a dig at our government, which in my considered opinion has let the people down. And hopefully I won't be locked up this evening, but we're also challenged by things like, let me say, ESCOM, where we have load shedding in the middle of the working day. And most recently, I was busy with an online, a very important thing. We had delegates from all over the world, and I had to literally run from my home into a neighborhood that didn't have power outage, where I could be accommodated by a family member to get online and get on with my work. So we're placed with extreme challenges in Africa. The reality is that, it's a very real consideration, where if it's not Wi-Fi or access to software, etc., we have all these other dynamics that compound our already compromised, let me say, hot seats as practitioners in the space. But all told, I'm still very, very optimistic about the real prospects of using mediation in the new normal to expeditiously resolve disputes and, get on with what we have to do to survive. Because, as you know, there's so many challenges to the real world facilitation and exposure. But that pretty much is where I'm at right now, Jackie.
Okay, thank you. That gives us a good segue to then hear from Funmi, who is very passionate about online media. Well, mediation in general, but online mediation. So Funmi, generally, mediation is not fettered by formality. We don't really focus on formality per se in mediation. But are there any protocols that might be necessary for an effective virtual mediation?
Yes, indeed. I think Adriani has done a fantastic job of laying the foundation. She's told us the importance and the benefits of mediation and ODR generally. But let me quickly say that conducting mediation virtually or fully online is not new, but it was the pandemic that accelerated its use in recent times. And unlike in-person mediation, when preparing to conduct virtual or online mediation proceedings, it is important to take the nature of any technology-based process into consideration. When the pandemic struck, it led to the development of a flurry of arbitration-related protocols for virtual proceedings, but a few of them can be modified for mediation proceedings. Indriani has referred to one protocol which predated the pandemic, which is the Untitled Technical Notes on Online Dispute Resolution. Now, those notes were developed to address the sharp increase in online cross-border transactions, which raised the need to develop effective dispute resolution mechanisms to deal with the attendant rise in cross-border disputes. And one of those dispute resolution mechanisms was ODR, to take advantage of the different advantages that Indriani has articulated. They were finalized in 2016. They are of a non-binding nature, but they are applicable to low-value e-commerce transactions. But the notes reflect and provide for the key principles of mediation: independence and impartiality of the mediator, effectiveness of the process, ensuring due process, fairness, accountability, and transparency. But more importantly, in the context of our conversation this afternoon, the note recognizes the fact that unlike in-person mediation, virtual proceedings require a system for generating, sending, receiving, storing, exchanging, or otherwise processing communications in a manner that ensures data security, privacy, and confidentiality of the virtual proceedings. But apart from the Untitled notes, there are other protocols for virtual proceedings, such as the Chartered Institute of Arbitrators Remote Hearings Guidance Notes. In the introductory part of that guidance note, it states that they can be applied to all forms of dispute resolution mechanisms: arbitration, mediation, negotiation, adjudication, and so on. We also have one that came in very quickly at the onset of the pandemic, which is the Delos checklist on holding arbitration and mediation hearings in terms of COVID-19. I would urge anybody who hasn't read the checklist to go and read that checklist, because it's so rich and so robust that hopefully it will outlive COVID-19. And I'm pretty much sure that online dispute resolution, virtual dispute resolution would outlive COVID-19, because we've seen the benefits of going online. We also have the IBA, International Bar Association Cybersecurity Guidelines, which deals and makes provisions for dealing with security risk when you are resolving disputes online. But my advice is that because mediation, because of the flexible nature of mediation, and because it's not a one-size-fits-all, I'd advise mediators to develop their own protocol. You can borrow from all the different protocols that are in the space, remembering that not all of them, apart from the Untitled notes, deal essentially with mediation alone. Most of them deal with arbitration, but I, for example, have produced my own protocol, which I share with the parties and which I fine-tune depending on the circumstances of each case.
You can't just leave us hanging. What is the FUNMI protocol?
FUNMI protocol on virtual
on virtual mediation.
But incidentally, I've shared it with quite a number of friends. And I also have my checklist, because I did some courses on how to conduct virtual or online mediations during the pandemic, during the lockdown. And one of those are the key things that you were told to do. Have a protocol, have a checklist that you can use for your mediations, and that has proved very, very useful for me.
Tell me, for me, how do you address there's a general presumption that people will have equitable access to technology. How do you address that in your virtual mediations? Is it the new sort of imbalance of power between parties? How do we address that?
Now, that is the subject of a full seminar, Jackie. I mean, believe me, it is something that is so critical because access and equity are principles of social justice. Access to technology involves access to tools, devices, internet, computers, and so on. And technology is now more readily available than it was about 15, 20 years ago. In fact, I always say that the cell phones are more than telephones. They are more like computers. We can do a lot of things on our telephones. And I say that they've democratized access to the internet. However, equitable access to technology means more than simply providing devices and connectivity. It's a complex issue that encompasses disparities in access to and uses of powerful communication tools because of differences in socio-economic status, gender, ability level, racial and ethnical identification, geographical location, as we've experienced this morning, Jackie, when we came on board, and handicapping conditions. It recognizes the fact that some people are more disadvantaged than others in being able to access services and facilities. And this barrier to access can be encountered in different ways, in terms of equipment, in terms of communication, even in terms of culture. Because in some places they'll tell you that, oh, it doesn't meet our religious or cultural requirements. And it is the responsibility of the mediator to address this lack of equity where it comes in. In the context of our conversation, I'll say that it means giving the parties the opportunity and access to mediators who understand the technology to be used and are able to assist the parties to use the different types of technologies available to them to achieve their goal of resolving their disputes through technology-enabled ODR. Now, this underscores the need for us mediators to understand and know how to use the different technologies. And wherever the inequality exists, we must deal with it in a manner that produces fairness. And so that is why sometimes you see us talk about the use of synchronous and asynchronous means of communication. When we talk about synchronous, we're talking about phone, which is accessible to practically everybody. We're talking about WhatsApp, which is accessible. We're talking about video conferencing, where you get immediate response. And when we talk about asynchronous, you're talking about the post. You're talking about emails. You're talking about fax, written or recorded messages. But you can find that in one mediation session, you may need to go from synchronous to asynchronous means of communication. You may have a party that has the best equipment ever, dealing with a party that doesn't have the same kind of access. So you may be on the same mediation session, texting, using text messages, using telephone calls, sending messages by chat. And that is what has brought in versatility to ODR. And it is important for us as mediators to know how to navigate the use of this in any given situation. So when we say that, is this the new frontier imbalance of power? The issue of power imbalance is actually real in mediation. And in the context, it means the ability to influence the outcome of negotiation in a preferred manner. When the mediator spends more time listening to the party with the greater facility, the tendency is to overlook the needs of the party that is not at that same level. And those are things that the mediator must be aware of, so that technology is not used as to the advantage of the other party. It can be quite challenging though, unless the mediator is well skilled. And the essence of virtual dispute resolution is to improve access to justice. But that access to justice must be fair to all the parties. And a critical success factor is the issue of trust. The parties must trust the mediator that no matter my handicap, that it has been recognized by the mediator. It has been acknowledged by her, and it has been dealt with by the mediator. So it must be able to bridge the gap between demographics, countries, parties that have access to modern information communication technology, and those who have limited access or restricted access. So it's a very, very fine line to thread when you are in that circumstance, but it does exist and you have to deal with it.
So for me, it sounds like in addition to all our training as mediators, where we learned, all the skills that Indrani alluded to in our opening, you now have to then develop some I would say, technology empathy and figure out how best to build a rapport with the parties, even as you attempt to progress the mediation on a virtual platform.
Absolutely, and that is why I said that when I speak more, if I'm given the opportunity, I'll explain some other things in the context of what you're talking about. But it's important for the mediator to earn the trust of the parties from the beginning, from the pre-mediation meeting. And that's why the pre-mediation meeting is not to be skipped. I wouldn't even go into a meeting without having a pre-mediation meeting, although to some extent it's institutional or it's ad hoc, because you'll find that in some ad hoc situations you're on your own, and all these things have to be planned by you. But in institutional mediation, the institute gives that backing for you, and you can actually have a conversation with them about how to deal with it. But deal with it you must.
Thank you, Funmi. Allow me then to move on to Hiro. Hiro, for whom it is now 6 o'clock in the morning. Thank you for joining us, Hiro. Based on the United Nations Convention on International Settlement Agreements resulting from mediation, popularly known as the Singapore Convention, please tell us a little bit more about the scope of the convention, the applicability, and its availability to parties.
Can you hear me now? Great. Thank you, Jackie. Hello, everybody. So let me give you some background on the Singapore Convention. So it was adopted by the UN General Assembly in December 2018. It went into force on August 7th, 2019. It was signed on August 7th, 2019, and it went into force just recently on September 12th, 2020. There are currently 53 signatories to the convention, 3 of which have also ratified it: Singapore, Fiji, and Qatar, I believe. And in brief, the Singapore Convention is to mediation what the New York Convention is to arbitration. It ensures, or it's intended to ensure, a fast-track and consistent method of enforcing mediated settlement agreements around the world. So the scope of applicability was the first question that you raised, Jackie. And essentially, the convention applies to mediated settlement agreements, that is to say, not a bilateral settlement, but one that was facilitated by a mediator, that is of an international character. And the international definition in the convention pretty much mirrors the definition of an international dispute in the model arbitration law. At least 2 parties have to be of different states, or the states of the parties have to be different from the subject matter of the transaction. Notably, the convention does not apply to consumer transactions. So any dispute over consumer purchase, for example, that was settled through mediation, convention wouldn't apply to that. It also does not apply to family, inheritance, or employment law matters. Settlements that could be enforced in the home jurisdiction as an arbitral award, or as a court judgment are also excluded from the scope of the convention. And the theory there is that there are other conventions, such as the New York Convention, that help with the enforceability of those types of settlement agreements. Let's see, is the convention available to all parties? Yes, in brief it is. One important difference between the Singapore Convention and the New York Convention is that there isn't the same idea of reciprocity that you find in the New York Convention. So with the New York Convention, the award has to be from a state that's also a party to the convention. With the Singapore Convention, there really isn't the same idea. And the theory, the basic theory as I understand it, is that unlike awards and judgments, settlement agreements have no nationality. So really the only important thing is that the state in which you are trying to enforce the award is a signatory convention. So for example, if there were a dispute between a US party and a Kenyan party, and that were being mediated in Nairobi, well, the US is a party to the convention. Kenya is not yet a party to the convention. The Kenyan party would be easily able to enforce the settlement in the US courts. But the reverse would not be true. The US party would not be able to go to court in Kenya and enforce the settlement agreement under the Singapore Convention. And again, the rationale, the basic rationale is that Kenya is not yet a signatory to the convention. So just because Kenya hasn't signed the convention doesn't mean that the convention is not relevant to Kenyan lawyers, right? So this is a good thing just to be aware of as you're advising your clients. Shall I say a little bit about the enforceability provisions of the convention?
Sure, go ahead.
Yeah, so essentially the convention is intended to avoid having to bring a breach of contract claim from scratch in a local court to enforce a settlement agreement. It's trying to kind of narrow the grounds on which, or the issues that a court would have to decide to determine whether a settlement should be enforced. So the general provision is that as long as you can authenticate that a settlement was reached, that it was reached through mediation and it's of an international character, etc., courts are obligated in convention countries to enforce those settlement agreements unless one of the exceptions applies, one of the grounds for refusing enforcement. And these grounds generally have to do with contract law defenses. For example, if one of the parties lacked capacity to enter into a settlement agreement, if the settlement agreement was procured by fraud or there was some mutual mistake. There are other grounds such as whether the settlement agreement has already been performed, whether the mediator failed to disclose material conflicts of interest, whether the mediator failed to adhere to standards of conduct. There's also the public policy and incapable of settlement criteria that you find in the New York Convention that were also replicated in the Singapore Convention. But the basic point is that these grounds for attacking a settlement agreement have been confined to just the enumerated grounds, so as, again, to narrow down the issues and really speed up the process. Now, this is a big question, right? How fast is the process really going to be? Because, you know, if one party says, well, this settlement agreement should be set aside because the other party lied to me, and it was on the basis of these misrepresentations that I signed the settlement agreement. Well, that could involve a very detailed factual investigation with witnesses and so on, and potentially a trial. So that's number one. And number two is that the convention really doesn't try to harmonize the procedure that'll be used in every country for how to deal with these questions. So these procedural issues have been left to local law. So I think there will be quite a bit of variation. Some countries have very efficient court systems that will be able to process these kinds of applications very quickly. Other countries have very backlogged court systems where it may take much longer to resolve many of these issues, and there may be other kinds of quality concerns when it comes to the enforcement process, as we've seen in the arbitration context. So this is really left to be tested. It's rather unclear exactly how much savings in time and efficiency the convention will bring about.
Just picking up then from that last point here, one of the goals of the convention was to encourage the use of mediation. Do you think the convention will actually trigger this global move towards mediation?
Yes, so I think this is really the million-dollar question to me, right? So on the one hand, there was a lot of fanfare around the convention. It was very highly publicized, and that has really succeeded in raising the awareness of mediation internationally. And I think that's been a very positive development. I mean, I think you all probably noticed the increase in the number of seminars and webinars about this topic, right? So that's very helpful because I think a lot of the challenges we face in the mediation space is awareness and education and getting lawyers more accustomed to the idea of using mediation. There were also several surveys that were conducted in about 2013-14 to gauge people's views of the efficacy or importance of having a convention like this. And about 50 to 70%, depending on the survey, of respondents tended to believe very strongly that an enforcement regime like this would be very beneficial in terms of increasing the use of mediation. I tend to be a contrarian on many things, and I think my view here is that I'm not sure. I'm really not sure the extent to which this kind of top-down, if you will, lawmaking or reform will really change actual practices on the ground. That's the big question in my mind. And I'll give you an example. So the EU in 2008 passed the EU Mediation Directive, which you may be familiar with. And the directive did provide that all member states need to develop a mechanism for ensuring that mediated settlement agreements are enforceable in all of the member states. Well, 6 years after the directive was passed, a study was done and found that less than 1% of all cases in the EU were mediated. So mediation was used in less than 1% in the entire EU. And what's notable about this also is that the EU has the highest concentration of jurisdictions with a mediation law. And despite all of that, despite the EU directive, only 1% of jurisdictions still really use mediation. And the number may have changed since then, but that study was done in about 2015, so just 5 years ago. It seems to me that a lot has to change, really, before we're even in a position to take advantage of an international convention on mediation. And I think one of those things is that mediation needs to become more accepted, really, for the resolution of domestic disputes. And Indrani was talking a little bit about some of the challenges in South Africa. This is not an easy thing to do, to integrate mediation into the legal system. As we know that there's a lot of resistance, for example, from lawyers, right? The alarming, alarming decline in revenues. Accelerated decline in revenues is a common phrase you hear. Lawyers have vested interests in their fees and in their practices, and they are always very often threatened by new developments. This was a case in arbitration a long time ago. Now we're seeing the same thing with mediation. Businesses often have apprehensions about using something that's unknown. Mindsets are very much kind of geared towards litigation and an adversarial approach. And I think it takes time for that to change, for cultures around litigation and dispute processing to change. One of the things that I'm very interested to hear from Justice Ocheng about is the court-connected mediation programs in Kenya, which I read a lot about and very interested in hearing about, because these are the kinds of things to me that are more effective in terms of changing attitudes and really kind of nurturing a culture of mediation. I'll tell you, in the US, this was what really helped us a lot. This was back in the late 70s, 80s. This is when the federal courts really embraced the idea of mediation pilot programs, and local courts carefully designed and supervised these court-annexed mediation programs. Judges came out in support of mediation and encouraged lawyers appearing before them to mediate. Lawyers were asked to volunteer as mediators, as volunteer mediators. We slowly kind of developed this culture at the local level on the ground. Mandatory mediation was also a technique that was used in these court programs. And the idea was you don't get a choice. If your case falls within one of these types of civil matters, you have to at least try mediation. Just come to the first session. You can leave after 5 minutes if you like, but at least try it, you know. So I'm very curious to know how this is all going to develop in Kenya, because I do think that court annex programs can be a very effective tool in growing this kind of practice, in changing mindsets. I tend to wonder how effective the convention will be in this regard. And you know, another reason why I think is something that Indrani touched on, which is that there generally is a very high rate of compliance with mediated settlement agreements, right? When you've reached a settlement, it tends to suggest that both parties feel it's better than their next best alternative, which is to, you know, pursue arbitration or litigation. With an arbitral award, I guarantee you one party is going to be disappointed, at least, maybe both of them, with the award. And so there is really that risk, right, of enforcement that needs to be addressed in a convention like the New York Convention. So for all these reasons, I think the jury is still out. You know, I don't want to poo-poo the convention. I think it's a brilliant, you know, development. It's really elevated the status of mediation, and it's given people like me a lot to write about, right? But I think one needs to really question how much of an impact it will make on the actual use or uptake of mediation internationally.
Thank you, Hiro. Might it also have any impact, or perhaps you may still have to conduct some research, but might it have any impact on international trade, the opportunities that lie for those of us that are engaged in drafting these contracts, in states that are entering some of these contracts? Where are the opportunities that arise from the Singapore Convention?
Yeah, I mean, if the proponents of the convention are correct, it will stimulate a lot of these things. It will lead more people to use mediation. Those of us who are advocates who represent clients in mediation will be more busy because clients will be more apt to choose mediation and so on. I don't know that there's much in the way of drafting opportunities that come up, certainly because of the various requirements in the convention about what types of settlement agreements are enforceable. There will be key drafting issues around the settlement agreement that lawyers will really have to study carefully, because each state can make a reservation on certain issues which do touch on the drafting process. So that's clearly something, but it's not at the pre-dispute stage, it's at the settlement agreement stage. Whether the Singapore Convention will actually increase trade or not, I think that's a very difficult question to be able to answer. I think we still don't know whether, for example, the New York Convention really increased trade around the world. I mean, that's the theory and that's the hope, and I think many people have made that argument. I can see that in the case of international commercial arbitration, primarily because, you know, international commercial arbitration is really the only alternative when you're talking about cross-border disputes, because the national courts are really not an acceptable option for most parties, right? Mainly for the neutrality issues. So international commercial arbitration really fills this gap that needs to be filled, because there's no supranational, you know, justice system. I'm not sure that's really the case for mediation. Mediation is certainly helpful for international trade, but it doesn't really provide, I think, the same essential service that international arbitration does. And so, again, I'm injecting a little bit of skepticism and being a little bit of a downer here, which I hope doesn't disappoint many of your viewers. But I do think it's important not to get ahead of ourselves and really be balanced about our optimism here.
Thank you, Hiro. In the spirit of optimism, let me turn to Justice Ochieng. We've previously heard about Kenya's success in enhancing access to justice through the court-annexed mediation project. What is the broad framework, which many of us are familiar with? And perhaps you can tell us more about what opportunities lie to enhance that framework.
Thank you, Jackie. Kenya is very lucky that the whole mediation thing is anchored first and foremost in the Constitution. By Article 159 of the Constitution, mediation is specifically mentioned as one form of ADR that parties must be given access to in resolving their disputes. We also have it in the Civil Procedure Act. So it's an act of Parliament as well. Apart from that, we have now got the practice directions, which have been formulated under the applicable statute. So it's pretty well anchored in law. But there's requirement or need to do more. We all recognize that there is need to do something about a mediation act, if you will, or an ADR bill. Both of these have actually been proposed. The problem is that if we go the Arbitration Act way, we may end up with such rules and structures that will kill mediation, because mediation must remain flexible for it to work. It is merely being facilitated by the mediator, unlike the court process, where the judge or magistrate sits and makes a determination following rules, or in arbitration where the arbitrator makes a determination. We must leave and respect that flexibility, which allows the parties to talk directly to each other when being facilitated by the mediator. So on the one hand, we appreciate there is need to have a little more regulation around it, but great care must be taken to maintain at all costs the flexibility of the system, of the procedures and so on. I like what Funmi said. You've got to adapt. You have got to maintain fairness between the parties, but not based on the rules enacted in a law, but your own perception of fairness to both the parties. Even where parties are of an equal background and strength, the power interplay between them must be regulated by a mediator. So you must be, as a mediator, possessive of skills more than your knowledge of either the law or of the subject matter that is the dispute between the parties. We have found that in Kenya, originally we started with the idea of, oh yes, to be a mediator, you must have a law degree. Not necessarily, no, sorry, not a law degree, a degree, not necessarily in law. Very quickly, we have come to the realization that a degree is not important if for you to be a proper, effective mediator. In fact, we have realized that in family matters, for instance, persons who work as social workers, some religious leaders are the perfect mediators, because already people have been taking their own problems out of their own free will, because you know that is a person of respect, a man or woman of respect, who is objective rather than subjective, and who will hear all the parties and help you arrive at a solution. So very quickly, we have realized, a degree is not necessary. So we are, for instance, dropping that. That's the kind of thing that we must, going forward, ensure that we maintain and retain for mediation to grow. You talk about success stories in Kenya. It's very interesting. There are cases, and I would just like to give a few examples. There are cases in the commercial division. A case, for instance, which was in the commercial division for 18 years. And it took 3 sessions, 3, at mediation, and a solution was found. And the people who had been fighting had their relationships restored after fighting in court for 18 years. Another one involving a spouse and a couple, rather. They were fighting over maintenance and custody. They had fought for 3 years in court, obviously very badly affecting the children, sorry. Within 2 hours of going to mediation, 2 hours, they resolved, they found common ground for the sake of their children. They appreciated that it's not about them. And they accepted that, look, between us, it may be over, but we have the children we produced, and we all owe it to them. And within 2 hours, they found a solution. So yes, there are many success stories. And that really is what motivates me about mediation. Well, what is the greatest success story, as far as I'm concerned, in Kenya? The greatest success story so far is the culture change that we have attained between us and the lawyers. What has been said in Nigeria and in the US is said in a lot of places. We are not an exception. Lawyers felt, look, this is a threat. The most interesting thing is that working with them, they have come to realize that this is actually an opportunity. It is not a hurdle in their path. So the very good lawyers, very well organized, have also become mediators. So the matters which cannot be resolved through mediation, which are going on in court, they pretty much try and ensure are dealt with by the court in the morning sessions. And then in the afternoon, the same lawyer is now sitting as a mediator. He's earning fees in both worlds. And the joy that they see in the faces of their clients when they achieve a settlement is what, to my mind, is driving a lot of these lawyers to appreciate where the place of mediation is in the system that we have. So I do commend the lawyers very, very sincerely for very quickly appreciating nobody wants to fight them. We are all lawyers, after all, initially. We have been there. I was in private practice for over 20 years before I became a judge. I would be the last person to see a lawyer losing out completely because they are having to go to mediation. And because parties do not pay a cent more when their matters are referred to mediation, nobody loses out. Even if you do not achieve a settlement, a complete settlement, you do not lose out because it's a maximum of 60 days at mediation. Usually it takes many more years in litigation. And therefore, if you do not find a solution, you lose nothing. You continue with the matter in court. So it's a win thing for everybody. Thank you.
Thank you, Justice Ochieng. One of the questions I'm often asked is the court annex mediation only available to parties whose matters have been screened by the court and referred to mediation, or is it openly available to other parties?
Thank you. As the name suggests, court annexed or court mandated mediation is in relation to matters which are already before the court. Therefore, the simple answer is it is not applicable yet. Matters where parties enter into mediation without having come to court. But we have received a lot of requests from people asking, look, why do you want me to come to court first and then refer to me to mediation? Why don't you open it up so that if you go to mediation and we find a settlement, I can bring it and record it in court so that if the other party does not do that which we agreed, it is immediately enforced. And we are actively exploring that. Only we did not want to try and mix too many things at the beginning when we are dealing with court annexed or court mandated mediation. It is something we are actively considering. We have also explored things that happen in Canada, for instance, and in a few other jurisdictions where there's a requirement in the rules that before you are allowed to proceed with your matter in court, you're asked to answer the one question: did you at least try mediation? If you didn't, you may have to be sent back to mediation. So rather than do that, why not open it up to the parties to go to mediation, and then you guarantee that you will use the court to be able to enforce if necessary. But compliance of mediation settlement agreements is literally 100% so far. Not a single case that I know of in the whole country has had to be taken through the process of execution through the court. Thank you.
So, Judge, in your observation, are there some disputes that are more amenable to the mediation process, or is it more a question of the parties and their acceptance of the mediation process, and perhaps also their lawyers' acceptance of the mediation process?
Well, yes and no. Yes, because I will answer that second. But no, because the court annexed or court mandated is not a matter of option. If your matter falls within the range deemed by the judge or magistrate or the mediation deputy registrar to be amenable to mediation, then it will be referred to mediation. So the court may refer the matter to mediation. And if you are referred to mediation, you are obliged to attend mediation. Of course, there's no obligation to settle, but at least attend, as Professor Hiro said. Okay? Attend. Now, if you are in court and you hear about mediation, or you are told about mediation, you may tell the court, look, give us the opportunity. So you do not need to be referred by the court. You can tell the court, we want to try mediation. And when the parties both say, we are ready to go to mediation, the court is obliged to refer them to mediation. And the court then, through the deputy registrar, appoints a mediator. Initially, we were offering them 3 options from the list of accredited mediators. Choose. That resulted in a lot of delays and so on. So we now, from the list of accredited mediators, we give to the parties 1 mediator. So unless the parties themselves agree on one, it is the court which chooses for the parties the mediator. And that so far is working very well. There are persons who have been known to help the parties reach settlements very quickly. And a lot of people are now saying, we want so-and-so. We are trying to be careful not to overload, because we may then end up with the results of backlog before a mediator. So there we are being careful, even when parties say we want so-and-so. If they have the time, we will refer. If we find they have too many because we are keeping a log of it, we sometimes say, look, they already have so many more. Do you really want to wait? Some of them say, if it's waiting for a month, it's worth it. After all, we've been in court for 3 years, so we may wait. But there are others who say, okay, is there another one? And we are trying to give to the parties as much information as we can about the mediators, and emphasizing that it is not the equivalent of arbitration, where a good person who is sitting as an arbitrator is good if they know the subject matter. In mediation, it is merely the ability to bring the parties to talk to each other as opposed to talking at each other. Thank you.
Finally, Judge, before we open up the floor to questions from our participants, how has the court then transitioned to virtual proceedings in the current COVID-19 dispensation?
Thank you.
For mediation.
As Indrani said, Corona is good and is bad, or is it bad and is good? It is a problem of health, which has therefore impacted the whole world. We are being forced to do things which perhaps we may not have had to do in the next 5 years or more. So, first we have begun with virtual courts. Why? Because those who opened the courts for too long, including some states in the US, unfortunately, regrettably, lost a couple of judges and some lawyers. Then they shut down. Kenya, luckily, was one of the ones to quickly shut down the face-to-face sessions. Of course, some people say, we have closed down the courts. We didn't. We merely scaled down. But we quickly realized that, look, you have got to give people an opportunity to go on with their cases. We started, therefore, the virtual courts. From the virtual courts, we learned, mediation, which was working very well and helping to ease off the backlog, is stagnating. So we engaged with the mediators, and they said we can try. And we did trials in Nairobi initially, and a couple of them worked very well. The uptake initially was not high because, for the reasons as Funmi said, there are quite a number of people who do not have the gadgets that you need to be able to conduct virtual mediation sessions. Slowly, mediators found ways and means of doing it, just like we are doing for virtual courts. There are parties who do not have smartphones or laptops or so on. What do we do for virtual court sessions? In Kisumu, for instance, we have 1 or 2 laptops placed in the open court. The judge or magistrate sits in their chambers. The party who does not have a laptop is given access and sits in front of the laptop in the courtroom. So that way we conduct the court sessions. In similar manner, those parties in mediation who may not have access to their own gadgets, we are encouraging the mediators to use their own where they can, or occasionally in the afternoons with prior arrangement, they can use our facilities. So it is proving to be a big hit, and it's already generally rolling out now to the rest of the country. Kisumu is doing well already after Nairobi and Mombasa. Thank you.
Thank you, Justice Ochieng. I'll now open up the floor to questions from our participants. I'll start with a question from Justice Joyce Watch. Her question is for you, Funmi. Back to our discussion around power imbalance. How do you deal with power imbalance, particularly in workplace mediation on a virtual platform?
That's a very good question, and believe me, it's a tough call because for workplace mediation, it's always better to have the parties in the room. But there are different schools of thought about how to deal with power imbalance. Some people say that power imbalance is a fact of life, and believe me, you should just let it happen in mediation as you would allow it to happen anywhere else. Some people say that it's the ethical responsibility of the mediator to try to strike a balance. Some people think that you should weigh more in favor of the weaker party. But it's critical for the mediator to have at the back of his mind the issue of the need for him to be impartial and independent of the parties, which is one of the critical areas mentioned in the UNCITRAL notes. And just like in any situation where there's a third party neutral, that must consistently be at the back of your mind. If you focus more on helping, quote and unquote, the weaker party, the stronger party is going to feel that you are biased, which is not a reputation you would like to give yourself at the end of the day. So what I would usually tell people is that in workplace mediation, the issue of self-determination is critical. The employer knows why he came to mediation in the first instance. So did the employee. They both know their partner, their best alternative to negotiation settlement. More often than not, you take it to litigation. So in that situation, we'll be doing more of reality testing. And even in my opening statement for workplace mediation, I usually make it a point that these are your alternatives if you don't agree on a negotiated settlement today, but what are the consequences of that? Rather than try to help one party, you let them realize that the issue before you is theirs, and that is, they have the right to self-determination, which is their responsibility to do it, and then do more reality testing with them in caucus, explaining to them and letting them, in fact, distilling from them, using sometimes different scenarios, role plays, and so on, and caucusing with them to try and not help, so to say, but explaining to them in a way that they realize that at the end of the day, the resolution to that dispute lies with them and what the alternative to settlement is. In a nutshell, because this is also another topic that we could go on and on about for a long time, but we don't have the luxury of that time. Well, workplace mediation is very interesting, but my experience with workplace mediation is that more often than not, the parties are willing to settle. And it's just a question of putting it within the context of the reality of the situation with them. More often than not, the parties are willing to settle. So that perceived power imbalance is usually not there, particularly when you have an employer who voluntarily came to the mediation and is not compelled to come.
Thank you, Funmi. A question for you, Indrani. What are the likely challenges of virtual mediation?
The likely challenges of virtual mediation. Wow. Whew, that's a loaded question. But I think firstly, it's ensuring that both the parties have access to in South Africa, if we're dealing with mediations down here, have access to Wi-Fi. And the other challenge would be, particularly with Zoom and Teams, the breakaway rooms, how do we maintain confidentiality? You've got to be so complicit, almost you would become complicit if you obviate those safety nets to ensure that there's no breach of confidentiality between the parties. Secondly, you can't really develop rapport as you would face-to-face with your parties. It's very difficult to engender the trust very quickly and build the relationship. So those are real challenges from a virtual space. But having said that, it does work. In fact, there are some benefits when parties see themselves on camera. They behave a bit better than they normally would in private sessions with the mediator. So those are real, humorous spaces and benefits to the whole scenario. And also, I guess, virtual mediations, you sit at home, so there's no challenge of traffic and venue. So there's benefits in terms of cost savings there. I could do a mediation sitting in South Africa with a party in the UK or in the States or wherever. So it really opens up an entirely much more expansive platform for practitioners that are in the space. So I'm giving you benefits, but challenges, I think, are pretty much what I've already outlined. Maybe the other panelists can add a bit more onto that.
Thanks, Indrani. Hiro, regarding enforcement of settlement agreements resulting from mediation, the question is, can you enforce the agreement in any signatory country, or should the country in which the enforcement is required have ratified the Singapore Convention?
The country has to ratify first.
Okay, I think that's fairly straightforward. There is another question for you, which I believe you're trying to clarify from the person that raised it, regarding arbitration clauses in contracts, if they're also manifest. I think, yeah, that question requires some more clarity. So Francis, if you could respond to Hiro's comment in the comment section, he had asked you for some clarity, then we can attempt to respond to your question. Francis is also requesting, Funmi, that you share your virtual mediation protocol for reference. And then for you, Justice Oching, there's a question from John Ohaga. He's referring to a recent decision in Ontario where a client sued their lawyer for negligent conduct in rendering advice in relation to a mediation. Do you think that is likely to have an effect in discouraging lawyers from advising their clients to refer to mediation?
Thank you. Frankly, I do not think it will have any negative impact on how lawyers advise their clients in relation to mediation. Why do I say so? In that particular case, it was not merely about, do I go to mediation? Do I not? It was a question about whether or not to accept. And if you do not accept that which has been put forward, what you could lose. So the lawyer advised the client to accept much less without having done sufficient background check. There was fear that the husband could go into insolvency. As it turned out, that was merely a possibility, and it turned out to be untrue. Having accepted less and signed the settlement agreement, obviously you cannot then open it because you did so voluntarily. The only option available to that party was to then go for the lawyer who advised her to accept the lesser amount. My take is that a lawyer ordinarily does not necessarily advise the client on what exactly to accept in mediation. Why? Because many times in mediation, the settlement is not about the rights. Very many times a lawyer could tell you that you have a good case and therefore if you win a defamation case, you could get 10 million shillings. But then you say to yourself, look, this is so-and-so, and if maybe they apologize and so on, and we are able to get on, it's not even the money. Let it be known by the whole world that he or she has gone out and confirmed what they said is untrue. It's bigger for me than the money. My name becomes clean. So you might find very many times parties say it is enough. I have seen this in particular with credit reference bureau matters. Your name as a customer of a bank goes into that list of a defaulter. And then it turns out that the information got in maybe a day or a week before you settle. And it remains there after you settle. Unbeknown to you, you then go to another bank to seek a credit facility. And the bank checks and finds, oops, you are blacklisted effectively. And there you are, you cannot get the credit facility you wanted. Now, if the bank that had caused you to be blacklisted apologizes to you very, very quickly, so that you are then able to get the credit facility from the new bank, that's really what you want to get on with, rather than fighting, why did you do this and so on. If you can get the credit, very many times people are getting on with their lives rather than fighting what they could have got. So that's the reality of life. Many lawyers, please don't get into the the detail of telling your client don't accept or don't accept this. That's not really your job in mediation. They formulate their solution to suit their circumstances. It doesn't have to answer the legal issues that arise from the case. That's not what mediation is about. It's finding solutions. Thank you.
Thank you, Justice Ocheng. Whilst I still have you on the line,
Sorry.
just a minute for me. Yes, I'll get to you in a minute. There's a comment within a question from Rupert Lipton, and he queries whether there's a downside to the Kenyan Constitution's reference to mediation. In his view, it creates the impression that mediation is something which happens after a case has been filed and cannot simply be entered into on the initiative of the parties. So how can mediation break free of court mandating, so to speak, and become a more natural choice for disputants?
Thank you. If it remained court mandated, then one would say it is perhaps a downside. But the Constitution does not mention the court at all. It talks about finding solutions to disputes. And this is why we are open to the suggestions being made. We are not going to limit ourselves to the court annexed or court mandated. Okay? The Constitution is so powerful, it talks about fairness and access to justice being made available to the parties. You don't have to be a party only when you are in court. When you are fighting with your spouse or your children, your parties to that dispute. Okay? So there's no downside to it in my considered view. Thank you.
Thank you. Funmi, you wanted to make a comment on the previous question?
Yes, indeed, Jackie. And the comment is just to talk about the role of lawyers in mediation. I quite agree with everything Fred has said. But at the end of the day, you realize that not all lawyers are knowledgeable about mediation and what their role should be. And that is why education is critical. In practice, what I do is if there's a pre-mediation session, I talk to the lawyers about their role. And at the opening session, I actually ask the lawyers, the parties, permission to meet with parties without the lawyers. Just try to downplay the role of lawyers in the entire process. So once I get that permission, because when I'm talking about the process, I'll talk about different ways of meeting with different groups. I can ask permission to meet with lawyers as a group, or meet with parties on their own, or meet with, the different combinations, so that I'm in essence telling the parties, or sometimes when I have a bullish lawyer who has spoken, I then turn to his client to make some contribution. So it's really, really important, and I'm quite happy to hear about this case. This is the first time I'm hearing about this case. I'd like the citation of the case so that I can use it up and tell lawyers that, look, if you're not careful, you're going to be the subject of a lawsuit if we have a party who is aware of his or her rights. So it will be an interesting case to study and to share amongst ourselves today. Thank you very much, Fred, for that intervention.
We will certainly obtain the citation for you. There is a question specifically for you from Chinwe, I believe in Nigeria, who conducted research, and some of the parties believe that court-mandated ADR has removed party autonomy in mediation. What are your views on this? Funmi, go ahead and unmute your mic.
Yes, yes, I have done so. It's still a question of perception and the fact that many people are not knowledgeable about it. Courts have mandated mediation. So court mandated.
Sorry, Funmi, we're losing you.
And believe me, when we say court mandated, it's not as if of the day you will be penalized in court. And it depends also on the mediation when it's court ordered mediation. Case with court.
Justice Ocheng, can I ask you to step in and respond while we try to reach Funmi on party autonomy in the context of a mandated program?
I lost the internet at that stage. I think I'm back now. Yes. And the fact that mediation is still, even though now becoming more popular, not all lawyers have embraced it. Not everybody is aware of benefits, and that is why the
Justice Ocheng, your views on party autonomy and court-mandated mediation?
Ultimately, when a party either is sent to mediation or chooses to go to mediation and is able to formulate their own settlement terms and so on, there is nothing they lose at all. At all. That's my simple, straight answer to it.
Okay, all right.
Can I chime in on this issue, Jackie?
Sure, Hiro, go ahead.
Yeah, so this is a controversial point, right? When court systems mandate that for certain types of civil cases, for example, everyone must attend at least one mediation session, is that not contrary in some way to the voluntary nature of mediation? And different people will answer that question differently. I know that in the States, we have come around to the conclusion that it does not, right? That in many ways, if you just make it a purely voluntary opt-in kind of system, especially when mediation is new, no one is going to opt in. No one is going to try that new thing that nobody has any experience with. But if instead you frame it as, you must try this, here's this option that you must at least try, well, people are more inclined to then try it, and if they have a good experience with it, to use it again. And of course, at the end of the day, just because you're being mandated to try mediation doesn't mean that you have to settle in mediation. It doesn't even mean that you have to stay in mediation for a certain period of time either, although that may depend depending on the context that you're in. And so it is, I think, a slightly controversial issue, but I think most jurisdictions have come around to the idea that it ultimately does not impact the voluntariness of the mediation process.
Jackie.
Thank you, Hiro.
Yes, I just want to make the point that Hiro had just made, that even when they use the word court-ordered, you don't have to do it. And you're not compelled to stay in the room if you are not comfortable with the process. I was given the example of an experience that I had where, the claimant was adamant that, no, the court forced me to come here and I'm not going to stay here, but I was able to calm them down and explain this is a voluntary process. Nobody's going to penalize you if you don't want to stay, but why don't you give it a shot? He gave it a shot and we settled the case in less than 6 hours. And in fact, he did a recording as a testimony to the fact that mediation works, and he became the champion of mediation. So when we talk about court-ordered, it doesn't mean that it terminates your right or your constitutional right to go to court or go back to court as the case may be. It doesn't. And for me, I think when people say that it make that kind of expression, it's because they don't understand the very nature of mediation. Once they understand it, they'll see that it is more or less still, there's no compulsion to mediation at all.
Thank you, Funmi. And Rani, did you also want to chip in on the question of voluntariness?
No, I was coming online to say bye to everyone.
Oh, okay. Before you go, there's a question, and I'm trying to clarify it with the person that asked it. Can you pursue a degree in online ADR in South Africa? So I'm trying to clarify whether it's a degree in online ADR or an online degree in ADR. Either way, are you able to answer?
In SA, I think UNISA has always been a correspondence university. On the online spectrum, I'm not too sure, but certainly I can't negate it. So if they could send their contact to me, I'm most happy to look up and respond.
All right, thank you.
If I may, Jackie.
Mm-hmm. Yes, Judge.
As I said earlier, even in Kenya, lawyers, quite a number of them, were initially, for instance, opposed to the idea of mediation or having their clients forced into mediation. They have turned around. Not only are they supporting their clients to go to mediation, they are becoming mediators, right? So when somebody thinks there's some compulsion, there's something you're going to lose or whatever, by merely going to mediation, that's why I say you lose nothing. You're being told by the court, please go and attend. You are not forced to say anything if you don't have to. And the experience of Funmi is something we have had in Kenya as well. There are people who have been completely opposed to And when they go there, they are screaming, they are saying all sorts of things, they're not going to talk. After they hear a very good mediator's opening remarks, they realize, oh, well, they are offering us the opportunity, me and the other person, an opportunity of suggesting a solution to this problem we have. And then they actually start talking. And that is why I think mediation is getting traction. Nobody is losing anything, I repeat. Thank you.
Thank you. I think this topic has ignited quite some sentiments. But in addition, Justice Ocheng, there are several comments from our participants who are suggesting to you that family mediation should be mandatory, for example, where children are involved. We have a participant, Sam, who suggests that because our prison cells, especially the holding cells at the police stations, are also congested, we can consider whether if a matter is mediatable, that it can be referred to mediation even at the point that somebody is still sitting in the police cell. So some food for thought for you.
Can I just comment quickly? Yes. On family, we are realizing a lot of success, Mm-hmm. We are not even contemplating making it mandatory. When people are seeing the success, they are asking to go to mediation. And we are seeing a lot of success in that field. It's bringing families back together in a lot of places. For prisons and things like that, we don't call it mediation because that's criminal nature. But remember, under the criminal law, there's provision for parties to talk in respect to certain kinds of offenses, the minor offenses. So that's already in the law. And yes, we are encouraging it, in particular during this time of the pandemic. And I think it will remain there after this thing goes away, because we are really encouraging it at the moment. Thank you.
Thank you.
Jackie, could I ask a question of Justice Ocheng?
Please do.
I'm just curious, Justice, do you have a sense of roughly what the settlement rate is in these court-connected programs in Kenya, and also the timing at which mediation tends to take place? Is it at the very, very beginning of the lawsuit, or is it after a certain time period has elapsed so that the lawyers have done some evidence gathering or arguments before the court? I'm just very curious to know what your experience has been in the court system.
Thank you. I actually have figures. The settlement rate currently is 50%. And we have been comparing ourselves to the rest of the world where there's mediation court mandated, and I think we're doing very well. Now, when we started the pilots, in the commercial division, we were very keen to have matters which are new referred to mediation. At that stage, we achieved minimal settlements. After about 2 years, we had a serious introspection. We had a good lady come out from Nigeria and very brutally honest with us. And she told us, "What are you guys doing?" Now, in contrast, family took their oldest cases first to mediation. They started achieving a lot of success. So comparing commercial to family, we realize, when parties have already been in court for a while, and you offer them a solution where they're not going to pay anything extra, and they can talk to each other, they are more amenable. So now even commercial matters, we are looking at the slightly older matters and saying, look, we are offering you this opportunity. And that's where we are achieving greater success. So that's the way it's working. Incidentally, we have now also suggested to the Court of Appeal, they have just incorporated into their final draft rules, which are being amended now, so that mediation is also going to be tried at the appellate stage. So that is just about to come out anytime now. Thank you.
Yeah, that's interesting. For you as well, Justice Ocheng, there's a question around employment courts, employment matters, where some courts have ruled that once parties attempt conciliation, time does not stop running in terms of the statute of limitations. Any comments on that?
I do not want to make a comment on if it's a decision from the court, because I don't think you can extend time that way. If it's already in court and you stop the time to go to mediation and so on, or try a settlement, that I can understand. But if somebody has not come to court at all, I don't know how you'll go around the statutes of limitation. So I don't know the context within which that could have been decided. But incidentally, some of the cases which are now being settled quite a lot, initially there was a problem, is employment matters. Interesting, why? Because some of the awards being given by the employment court were quite high. And employers are realizing that I better start talking to this person, even though I fired them. And the employees are also realizing, instead of fighting for the next 2 or 3 years, if the employer is ready to come down, talk to me, and maybe I get something over the next 6 months or 2 months or whatever, it's better for everybody. And they are actually now beginning to achieve a lot of positive settlements.
Thank you, Judge. A question perhaps for you, Funmi, and Indrani, if she's still with us. How can a mediator handle raising emotions in the course of a virtual mediation?
I would say that dealing with emotion is a factor of mediation, particularly when they're dealing with issues such as employment issues, workplace disputes, family disputes, and so on. And for me, it's pretty much the same way, because you have to realize that emotion and empathy are different. You don't go to the mediation and sympathize, oh, I understand, and I mean, just like agree with the emotions that is being displayed. So for me, you have to recognize its existence, you have to respect it, and work with the parties to deal with it. It's just as simple as that. You can do it virtually. You don't have to be in the same room, because you're not going to go hugging the parties when you're in physical presence of one another. You're not going to sit beside them, hold their hands. So you do what you do best, even online. It's for me, it's as simple as that. I've had cause to do that in recent times, and I've done it successfully. The important thing is you must recognize the fact that it is there. That is critical, and you must respect its presence and then deal with it, but not by sympathizing and showing, which you can't in any case, since it's all virtual nowadays. Yes, so that's my simple answer to that.
May I latch on there, please, Jackie?
Yes, please.
I agree. I completely agree with Funmi on that. However, obviously, it's very important to get them to feel acknowledged, heard, and understood, so that we can show empathy to the anger and try to empower them into prospective thinking to advance the negotiation, not to keep them entrenched in their position. So if the anger continues into further sessions, then we must assert some degree of, almost to say, look, we've dealt with that, so it's really not helping to keep yourself in that entrenched position. Consider this, consider that, and that's how you advance and dilute the anger from sitting heavily in the mediation. Because there's a time for it, but it must go once it's been addressed. Otherwise, it's going to be a barrier to the forward movement that is so necessary in a mediation.
Thank you, Indrani. Perhaps an open question for all our panelists. Any advice on institutions that specifically offer a master's in mediation?
Don't come to South Africa. No, look, it's very difficult. You have to be on a panel, get invited, the way it normally works, I think. But certainly, like I said, it's growing. And hopefully we'll have a panel in Africa soon. Panel of mediators for thematically oriented commercial disputes, where you are a quantity surveyor presiding over a matter on costs, or as Fred has said, you don't really need to be a lawyer or an expert. So who knows where the space will go? But that's my sentiment.
Thank you, Indrani. Anyone else with any comments on that question? Masters in mediation, no? Okay. I'd like to bring us to a close with slightly 10 minutes over time, but that was because we had quite a few questions and comments from our participants. I'd like to thank our panelists, each and every one of you. Thank you for honoring the Center's invitation to sit on this panel this morning, this afternoon, depending on where you are. And at this point, I'd like to hand us over to the Center's Registrar, Lawrence Ngugi, to close our webinar. Thank you to each and every one of you and to all our participants.
Pleasure.
Thank you, Jackie. Thank you to the panelists. We couldn't have had a better panel to canvass the exciting discussion we've just gone through. I've learned quite a number of things. Thank you, Judge, for clearly laying out the points covered in the Ontario case. I'm sure it will be of great interest to the participants here. As we draw to the close, I want to thank the participants for staying with us. Just to mention, NCIA is, although an arbitral institution, but also involved in the mediation space. And one of the things that we, out of assessing the practice of mediation, have developed is a course in lawyering in mediation and arbitration. So just acknowledging that the mere fact that we happen to have gone through law school for some of us did not necessarily prepare us for mediation or other forms of ADR. So look out for our courses. We already have a calendar for this training, and in particular, lawyering skills in mediation and arbitration to prepare the lawyer and any other practitioner for their role, either in mediation or arbitration. Perhaps we could avoid some of the consequences that the bar in Ontario has found itself in. I think as a parting shot, we as institutions for ADR, and in particular now mediation, are committed to not only develop capacity in this form, providing platforms for experts as we have had today to share with us their practice from the field, but we are also involved in the actual space of conducting, facilitating the process of mediation. I think Fumni did mention the question of protocols. We as institutions are best well suited to support mediators, one with facilities and two with protocols so that they can engage in the actual business which they do, which is to mediate, and then leave the administration bit of it to us. So we are there to offer this kind of service. To Judge, we are willing to support the court process in terms of parties who may not have the actual tools. We are tailored and custom made for that. So where the courts find they do need the services and facilities, NCIA will be more than happy to support. With that, we do appreciate the time spent with these panelists here. We thank you for your insightful discussions, and we do look forward for another time when we can have a discussion on mediation. Certainly, coming month, look out for our next webinar. Thank you, Ms. Jackie, for ably, sorry, not mediating, but hosting this session today. Thank you very much.
Thank you all, and goodbye.
Thank you. Bye-bye.
Thank you. Thank you. Bye.
Bye. Bye, guys.